Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. I'm looking at a book which is very important for me certainly, and for many people who deal with family matters. It's from the Law Society Publishing, and it's called Family Law Arbitration. It's this blue book here. It's got a subtitle, A Judicially Recognised Alternative to the Family Court. It's been written by a man called Dennis Sheridan, who is a solicitor and family law arbitrator. That's the back of the book. It's a very light book. It's paperback basically. It runs to a total of 83 pages. There's no index at the back, but you can, well, in fact there are appendices. That's really all you've got. That's Appendix 8 at the back there with references. And then as you go through it, there are various other appendices. The Arbitration Act is covered in great detail, which would be expected, and what you have got is a variety of, again, the actual family law arbitration scheme is also covered, which is Appendix 1. Then the actual body copy, if you like, of the book is actually only about 15 pages long. We've got paragraph numbering at the sides there. You see the benefits of arbitration and mention points to note. And there's also procedure, which again, if you've done the course, you'll know basically what they're going to do. Do have a look at the preface, which is well worth reading. There's also some acknowledgments to see who's been involved in producing this. The actual contents as such are set out there, so it's relatively simple, straightforward. And you've also got a little bit there. And you've got the case of where is it? S versus S 2014, which is actually a case report on page 77, which is part of the appendix, and that's actually the front of it there. So it's a very light book, a very important book, I think. It's part of it's also linked in with the Institute of Family Law Arbitrators, who've got their little logo on the bottom there. Let me tell you what we think of this book, because again, I think it's an important one, bearing in mind what is happening within the family jurisdiction as such from April 2014. I'm actually recording this in the summer of 2014. Obviously we're beginning to see now what's happening with the creation of this one family court structure to take over from the three distinct different courts that we had in the past. We've given a title to the review, which is on the web and in the journals, of Arbitration Flies OK, the new rules for the family law arbitration scheme. Now, it's a very difficult one because arbitration is not necessarily the way forward in every case, but certainly the view of the people who run things is that we should be going much more down the arbitration mediation route. And in some ways I can see from my own practice that has had a benefit. It doesn't always work, but it does in quite a few cases. So I can see why there is this inclination at the moment to push it forward, because frankly I find the adversarial system is probably not appropriate in some of these cases where you've got the warring mum and dad and you've got real problems, and possibly an inquisitorial approach in my view might be a better approach. More about that on another occasion. Let me say this, so the year 2014 saw a massive change in the way in which the family court jurisdiction operates, and we believe that the most significant aspect of this change is the concept itself, and often the insistence that family disputes, no matter how disputatious, should ideally be settled by a dispute resolution, such as arbitration mediation, without necessarily going to court. And that seems to be where we're moving towards at the moment. Or if litigation proves necessary, which is all too often the case unfortunately, arbitration should precede it. But there again, it's the old story of taking a horse to water, but you can't necessarily make that horse drink. And it's the same with the clients, as I'm sure you are well aware, as those of you who sort of do this regularly will know. Within, therefore, this innovative and continually changing legal landscape, the publication of this new book from the Law Society we think is timely. It's a concise guide to the process of arbitration in family disputes, and it contains the key legislation and case reports, plus the relevant forms, statutory materials and recent judgment in S and S versus S, which I mentioned is at the back, because the bulk of the book is actually the appendices. All advisors, we think, in family law matters, whether you're a barrister, solicitor, arbitrator, paralegal, or general advisor, and they come in all different forms. The CABs may be interested as well, of course. They should note that this is the only publication on this specific topic, and certainly the only one with the relevant materials in one place at the moment. Mr. Sheridan has come up with a winner here, I think, because he's a trained and accredited member of the Institute of Family Law Arbitrators, as is his colleague Sir Peter Singer, who's written the foreword right at the front. Now, the family law arbitration scheme, which is set out in the first appendix, is clearly and succinctly described, and Sir Peter explains that the emphasis is on the potential advantages of arbitration conducted within the rules of the scheme, as it's called, in accordance with family law in England and Wales, and as an effective alternative means of resolving financial disputes. It's basically about money. The old ancillary relief, now renamed financial remedy, financial disputes. And the idea is that, I mean, even if you go to court, the idea is that you will get some indication from the judiciary as to what the judge thinks. And that will save a great deal of trouble if you're going to have a full trial to try and get at the facts, if there are lots and lots of little porkies being told about how much dad and mum actually have. And that again is a problem, and we see it in the newspapers, even with some of the reported cases where they're not really telling the truth about what their assets are because they've hidden them, which is quite easy to do. As we have a global economy, it's not that difficult these days to do that sort of thing, and I'm seeing it more regularly, I'm afraid, unfortunately, but there we are. Now, Sir Peter goes on to say that he uses an elaborate yet homely metaphor to describe the possible benefits of an alternative arbitration process. He says the parties themselves can feel far more involved in shaping the resolution of what is, after all, their dispute, rather than being made to feel that they've become a piece of litigation luggage on a long and congested conveyor belt, limping with fits and starts to a final court hearing. Now, I have to say I agree with that, because my experience advising clients is that it is a much better way of trying to end the angst and the aggro, instead of these long protracted hearings which can last years, and it doesn't do anybody any good, and I think it damages the kids, frankly, because they know what's going on. They're not stupid. At least we've had some changes that recognise that children do have minds of their own and they know what's happening. And it is an important factor, I think, to bear in mind. We do have the Children Act, and we should be bearing in mind Section 1, as usual. Let me go on. Arbitration, says Sir Peter Singer, is more of a fast track, where if you choose to take only hand luggage, to use his allusion, you won't be bumped off the flight. That's why we said arbitration flies okay as our headline. The contention here then is that arbitration works as effectively for those travelling economy as it does for those privileged folk in first. It's published, I think, in a convenient management report format by the Law Society, and this slim handy volume, we think, contains everything you as an advisor will need to know about family law arbitration, from appointing the arbitrator to enforcing the award. The 8 appendices, including a checklist, will steer you through the first meeting, plus the arbitrator's terms of engagement if you're not used to what they're going to do, a draft letter to HM Courts and Tribunal Service, and more besides. Let me conclude by saying that if you're involved, we think, in the family law arbitration system at the moment, or plan to be, this is a publication you've got to acquire from the Law Society. It's not expensive, and it will be very useful. The date of publication is cited at February 2014. To show it again, that's the book. I'm recording this in the summer of 2014. That's the back, which sets out a little bit of what's in it. And as I said, it's very light. You've got the Arbitration Act itself right in the middle. You can see all of that. You've got a lot of stuff, and as I said, Sir Peter Singer's foreword, I'll just move that back a bit, is actually well worth reading, because it sets in, he says, Dennis Sheridan's book very handily fills a space in the rapidly developing landscape of optional dispute resolution procedures. Remember the word optional is used there, but as I've indicated, we may be moving into a different regime at a later stage. We shall have to see. In the meantime, thank you, Mr. Sheridan, thank you, Sir Peter, and thank you, the Law Society. As I said, do look at our review, which is on the web and in the journals, and thanks to all concerned. This is very useful. Bye-bye.